community of Kahnawake to welcome Senator St. Clair to the territory. So please join me in welcoming Mr. Michael Loft.
My name is Mike Loft. I'm a lifelong member and resident of Kahnawake, nearby Mohawk community. On behalf of the Ganyankahaga, or Mohawk as we're known in English, I want to say Tegwanuwarado. That means welcome everybody. And I extend a warm welcome to everyone, especially our honored and esteemed guest, Senator Murray St. Clair, who's there with us on Skype. I hope you're feeling better, Senator. As we know, Senator St. Clair headed the Truth and Reconciliation of Canada, along with Dr. Marie Wilson and Chief Wilton Littlechild. After 5 years of direct consultation with residential school survivors, the TRC's work ended in May 2015, culminating in a final report that found Canada guilty of committing cultural genocide against Indigenous people. Importantly, the Commission also made 94 important calls to action, which I want to talk a little bit about. Of these, there's one that's near and dear to my heart. Action number 63, section 3 of the calls, building student capacity for intercultural understanding, empathy, and mutual respect. Okay, that's what Jackie, my friend here, is doing every day. Action 63 is personal for me because this is what my late father Mitchell, a residential school survivor from Spanish, Ontario, this is where he went. He always wanted to bring understanding between Canadian people and Indigenous people. Last May, I retired from McGill University after teaching social work for 10 years. Sometimes my dad would accompany me during those years when I taught a class, and he wanted so badly to speak on his experiences to my students. But he could never utter a word. He would totally freeze up and lock up, and it was pretty sad in front of the class. And such were the effects of human beings losing their voice through those institutions. He never did achieve his goal to speak on his experiences, but the TRC calls to action gave me and my wife Ruth, who's sitting right there, who is a residential school survivor, the impetus to carry on his dream, his path to reconciliation through education. Together with other Native and non-Native supporters and staff at McGill, we have gone even further than that, managing to convince our school to relocate the Hochelaga Rock or monument from its former location in the shadows under a tree, okay, at McGill, to a highly prominent position directly across from the James McGill statue and the lower campus at McGill, which is a wonderful thing. It took only about 4 years of effort. For your information, that Hochelaga Rock commemorates the meeting of the Iroquois and Jacques Cartier in 1534. And that's a whole other story, but it's a wonderful story. The TRC calls to action are being felt at other institutions around the city as well, which I'm very proud of. For example, in February, Montreal Mayor Denis Coderre announced the city's plans to add a Native symbol to Montreal's coat of arms during Montreal's upcoming 375th year anniversary founding of the city. Adding a Native symbol to the flag of Montreal, along with the shamrock, the fleur-de-lis, the Scottish thistle, I think, and one other one, is very important. I think there's only 3. It signals to Indigenous people, once that's up there, okay, that we're included now. Just like moving that rock was a big deal. You know, we're in the shadows, out of the way, and nobody even knew that Hochelaga Rock was there. Now it's front and center, okay? And so will be that symbol when it's on the coat of arms of Montreal. So it signals to Indigenous people that we're included now, we're visible, and it's starting, okay? And I believe it's through the calls to action and the work of the TRC in this country that things are starting to move slowly. And let me tell you, this feels good to know that Montreal's planning to do that, and I could say to merci Mayor Coderre for that. In closing, we have the TRC to thank for spearheading this movement in Canada. The true history of First Nations, Inuit, and Métis will finally be heard, and negative attitudes and distrust will slowly dissipate and go away. And this is truly education, okay, for reconciliation. As Alice Hoffman wrote, once you know some things, you can't unknow them. It's a burden that can never be given away. Nyawangoa, Mr. Sinclair, once you know thank you for all the work you've done on behalf of Canada and the Indigenous people. We're truly grateful, and I went to several of your events, and I know all the work that you put in, you and your team. It's unbelievable. I don't know how you did it. So thank you very much, Nyawangoa, Mr. Sinclair, and let's please give a warm welcome to Senator Sinclair before someone else comes up.
So welcome everybody. Senator Sinclair, it's a pleasure to introduce you today. Senator Sinclair served the justice system in Manitoba for over 25 years. He was the first Aboriginal judge appointed in Manitoba and Canada's second. He served as co-chair of the Aboriginal Justice Inquiry in Manitoba and as Chief Commissioner of the Truth and Reconciliation Commission. At the head of the commission, he participated in hundreds of hearings across Canada, culminating in the issuance of the commission report in 2015. He also oversaw an active multi-million-dollar fundraising program to support various commission events and activities, and to allow survivors to travel to attend commission events. Senator Sinclair has been invited to speak throughout Canada, United States, and internationally, including the Cambridge lectures for members of the judiciary of various Commonwealth courts and tribunals. Il a été également professeur de droit à l'Université du Manitoba. Il était très actif au sein de sa profession et de sa communauté. Il enseignait le droit autochtone. Il a remporté de nombreux prix, dont le prix national d'excellence décerné aux Autochtones, le prix Égalité de l'Association du barreau du Manitoba en 2001 et son prix de reconnaissance pour service exceptionnel en 2016. 8 universités canadiennes lui ont également décerné un doctorat honorifique. Il a été nommé au Sénat le 2 avril 2016. Murray Sinclair's Ojibwe name is, I'm sorry for the pronunciation, is Mizanagwizik. Am I right? And you know what it means? The one who speaks of pictures in the sky. And truly, he has inspired so many of us in working tirelessly for social justice and for peace and for reconciliation and for forgiveness. But as Mahatma Gandhi once said, to forgive is not to forget. You know, Tuesday, Murray Sinclair offered a powerful response to Canadians who wonder why Indigenous people don't just get over the trauma of residential schools. He said, and until people show that they have learned from this, we will never forget. And we should never forget, even once they've learned from it, because this is part of who we are. It's not just a part of who we are as survivors and children of survivors and relatives of survivors. It's part of who we are as a nation. And this nation must never forget what it once did to its most vulnerable people. It is a great privilege and honor to welcome you, Murray Sinclair, at the Vanier Conference on Justice and Accountability.
I want to thank you very much for that very wonderful introduction, and for all of those who are in attendance and watching this presentation. I also want to thank you for allowing me to be part of this event, even though I couldn't be there with you in person today because of a medical condition I have which needs to be addressed this afternoon. I wanted to be sure to try to participate as much as possible and share with you some of my thoughts about the issue of Indigenous people and justice and coming to terms with the injustices of the past. I also would like to thank Elder Mike Loft for that kind set of words and for his reflections upon the impact of the Truth and Reconciliation Commission report upon his life and the lives of those around him. And I'd also like to thank the Mohawk people for allowing this event and for me through this technology to be present in their territory in order that we can have this conversation. I want to talk to you today about the history generally of Indigenous people, law, and government and society from the perspective of the impact that has had upon Indigenous people, in order that we can come to a bit of an understanding about why the relationship between Indigenous people and non-Indigenous people in this country is as it is now, and how it came about. And we can understand, therefore, what it is that must be done in order for us to be able to move forward. I want to begin by telling you that the ambition of the Truth and Reconciliation Commission was to show the truth of the history of residential schools in this country, but also to reveal as part of that the truth about the evolution of the relationship between Indigenous and non-Indigenous people since Confederation, as led by the Government of Canada, but also followed on by the efforts of the various churches and church entities in this country, and by society generally. Ultimately, the Commission was charged with the responsibility of talking about reconciliation and what reconciliation meant. And it should be no surprise to anybody to know that reconciliation is a difficult concept for most people to get their heads around, mainly because it has so many different definitions. It's not because it has a definition that's hard to understand. There are just so many different ways of looking at the whole issue of reconciliation. Some have talked about reconciliation in the context of forgiveness, for example, and that true reconciliation cannot occur unless there is reconciliation within your own heart. Archbishop Desmond Tutu, who was the chair of the South African Truth and Reconciliation Commission, firmly believed that reconciliation was not meaningful unless the individual victim of acts of violence in the past was able to forgive not only the perpetrator, but to give himself for the way that he has lived as a result of what the perpetrator did to him. And so the ability to reconcile with the perpetrator in his mind meant that you were able to forgive the perpetrator and come out of that relationship or come out of that dialogue with a heart free of anger, despair, sadness, and with a heart filled with hope for the future. We took a different tack with regard to the issue of reconciliation in Canada, because we know that for many people there is no desire to continue to have a relationship, and there's a difference in philosophy about the impact of forgiveness and the teachings around forgiveness in Indigenous thinking. So we approached the issue of reconciliation from the question of what does it really mean to the importance of the relationship between Indigenous and non-Indigenous people. And we concluded that reconciliation really was about establishing a relationship of mutual respect between Indigenous and non-Indigenous people. And so we did our work with that in mind, and we challenged ourselves to think and to rethink that concept from time to time to see if it was still viable. And at the end of the work of the TRC, we came to the conclusion that it was still a viable way of looking at reconciliation. And so in our final report, those of you who have an opportunity to see it will know that we continued to work with that concept very much in mind. In order to appreciate what it was that we were thinking and what we're talking about when it comes to the relationship between Indigenous and non-Indigenous people. However, we need people to understand that before we can get to the conversation about mutual respect, we need to understand the importance of putting Indigenous people into a situation where they can have self-respect. And that self-respect is very important. I've asked the technicians at Vanier College if they could download a video that the Truth and Reconciliation Commission helped put together with the assistance of a songwriter by the name of Aaron Peters. He did a video called Perfect Crime, in which he shows from a young person's perspective what it's like being a young Indigenous person today in Canadian society. And when you have a chance to see the video now, I hope you'll be able to see it, then we can talk about how things have evolved to that point in time and what needs to be done going forward. So I'd like you to watch that video, and I hope that the technicians can put it on display.
Dream I had about going home never ever did come true. Lie broken like the promises that litter every street and every alley in you. ones cry out. Don't let what happened to us be forgotten.
Am I back on screen now? All right. I wanted to mention to those who are watching on video from other locations that they wanted to see that video and they weren't able to see it on this particular event at this time. It's available on YouTube, and you just have to search for a video called "Perfect Crime" by Aaron Peters. One of the reasons why that video is so powerful is because it actually reflects what's going on in the streets of our country today. Young Indigenous people are being caught up in the justice system and the child welfare system, and are leaving their families and living on the streets and living from house to house in tragically large numbers. It has to do with family breakdown to a certain extent. It has to do with family disruption by child welfare and police authorities, and the failure to assist young people to reunite with their families, with their parents. And as a result, there's a large number of young people, even today, despite all of the growth in society that we have seen, where they are still feeling lost and in fact living a lost existence. But in order to understand why things are like that, I'd like to go back to Confederation in Canada, 1867, when this country was formed by legislation from England. There was an approach to the establishment of this nation which largely ignored Indigenous people, and in fact it was only because the government of England required the Canadian Federation to have to enter into treaties with the Indigenous people of the West if they wanted to expand further west than the original colonies that came together to establish Confederation. And so because of that, the government of Canada had to come to terms with the Aboriginal title, the rights of those Indigenous people who were there, and their interests. During that process, the government took the approach that it was largely a land transfer and a land resolution question. But from the Indigenous perspective, they actually saw it as a situation of establishing and defining a relationship going forward. The relationship had already been defined to a certain extent in an earlier document in 1763 called the Royal Proclamation, 1763. In the Royal Proclamation, which followed the French-English War of the 1850s, the Crown and Right of England, who had fought for 7 years against the French, not only in North America but around the world, were quite militarily weakened in North America. They were concerned that if the Indians of North America, the Indian tribes of North America, took up arms against them, that they would be unable to resist them. So as a result, the Royal Proclamation was issued in 1763 for the purpose of assuring Indian tribes that the Crown had no desire to interfere with them, had no desire to take over their lands, had no desire to do anything to the way that they governed themselves and dealt with their own issues, and that the intention was that it would be a relationship of equals, and that if the Indigenous tribes were prepared to enter into treaties to allow the Crown to put settlers into their territories, the Crown would be willing to do that, but settlement would not be occurring until the Indian tribes agreed to it. And their right to govern, even in the face of that, would not be interfered with as well. So the Royal Proclamation of 1763 was the first declaration by the Crown in North America, the British Crown in North America, that the relationship with Indigenous people was going to be respected and one of mutual respect. The Royal Proclamation of 1763 was not merely a Crown statement, however. It was a document that was then circulated amongst the Indian tribes, and they were called together at a large gathering at Fort Niagara in 1764. And the Royal Proclamation was explained to them in their languages. Some of it was translated into their languages, and they were asked if they would indicate agreement and acceptance of terms of the Royal Proclamation. And 3,800 leaders who came to that gathering at Fort Niagara in 1764 indicated that they would agree to the terms of the Royal Proclamation. And so as a result, a peaceful relationship and a relationship of mutual respect was established as a result of the Treaty of Niagara of 1764, which continued for over 100 years. Confederation, though, changed everything. In terms of Confederation, the government of Canada, led by Sir John A. Macdonald, the Prime Minister, decided that they were going to do things their own way. The British Crown had always been leery of giving power to colonial leaders, and in fact, always insisted that Indigenous relations or relations with Indian tribes or Indigenous people were the prerogative of the Crown agents in England. And I think Confederation shows why that was the case. The colonial officials in Canada after Confederation were assigned responsibility at the federal level in Section 9124 of our Constitution Act to be responsible for Indians and land reserved for Indians, as it was called. And so after Confederation, the relationship between Indigenous people and government officials transferred from the British Crown to the Canadian Federation, and in particular the federal government. And they immediately set out to deal with the issue of Indian title to lands in the West because they wanted access to those lands. And treaties were entered into. In the course of the treaty-making process, as I said, the government really wanted just to get Indian title transferred, but Indigenous leaders wanted more. And in fact, education was one of the most important parts of the conversation. When Treaty Number 1 was signed in 1870, the Crown came prepared with a land transfer document, but the Indigenous people insisted on other provisions being agreed to. And in fact, and as a result, another document called the Outside Promises Treaty had to be signed, containing all of those additional promises. And one of those additional promises that the Indigenous people asked for was a promise by the Crown to build schools on their reserve so that their children could be educated to be as educated as the little white children in the colonies. And that became the government commitment. So in Treaty Number 1, we see a provision which says something like, Her Majesty agrees to maintain a school on each reserve, hereby made whenever the Indians of the reserve should desire it. But the government had a very different agenda. Even though they signed that document, almost immediately they started to develop a policy based upon their assertion that Indigenous people in the West, Indians, tribes, were uncivilized, were inferior people, were heathens, and were savages, and that they needed to be civilized through their own form of education system and through Christianization. Sir John A. Macdonald, who was the Prime Minister of Canada, stated in 1883 that we would put them in central training industrial schools where they will acquire the habits and modes of thought of white men. So his intention as Prime Minister of the country was to remove children from their families solely for the purpose of assimilating them forcibly, if necessary, into Canadian society. But it was the separation from families that was behind their approach. They took a multi-generational approach. They knew that it was going to take some time. And in fact, initially for the first generation, We know that residential schools were facing challenges of getting people to send their children there. But they were able, through coercion, through withholding of rations, withholding of food, through military force, through the force of police authorities, to remove children from their families and to place them into those distant institutions. The government also very quickly involved churches and missionary societies in their work because they saw them as being relatively free labor, devoted to their missionary zeal, and able to do the government's handiwork. In 1883 as well, the government had to set aside a large amount of money in order to start building these schools. And Public Works Minister Hector Langevin, in explaining the need to get that money and to establish schools, said, in order to educate the children properly, we must separate them from their families. Some people may say, he said, that this is hard, but if we want to civilize them, we must do that. At the same time, you have to keep in mind that in the southern part of North America, in the United States, the government of the United States had taken a very different approach of declaring war against Indians. War against the Indians had started in the 1860s and continued for a period of 20 and 30 years. And so the government of Canada was concerned about potential political and military unrest among Indians in Western Canada. And they came to recognize that if they had the children in government care, then at times of political unrest, Indian leaders were unlikely to go to war against Canada because the government had the children in their care. So they were prepared to use the children almost as human shields. And we found references to that particular approach and that logic and that basis for doing what they did in several government documents that we did when we researched this at the Commission. So you can see then that the government's decision to establish these centralized residential schools, which they called training or industrial schools at the time, was not the model of education that the governments negotiated in the treaties. And in fact, while they were building the residential schools and refusing to allow schools in the reserves to be built, the government continued to promise until 1925 that they would build schools in the reserve. But clearly the model for their educational approach was not the model that was being negotiated and placed in the treaty. So you can see residential schools were a breach of the treaty promises even before the treaty promise was made. They passed laws to make it mandatory for parents to send their children to the schools designated by the government. And even from the beginning, right in the 1880s, we can see concerns being expressed by Indigenous parents and leaders about how the children were being treated in the schools. They knew and they learned from their children when they did get a chance to see them that language and cultural traditions and practices were prohibited, that children were being prohibited from speaking their languages, and that corporal punishment was being administered freely. They knew that their children were being demeaned and humiliated from the beginning, and that they were being told that they were savages, pagans, heathens, inferior, and dirty. They knew that their children were being separated from each other, so brothers and sisters were separated, prohibited from speaking to each other, and older children were being separated from younger children in the same family. So parents had mixed feelings about sending their children to the school, keeping in mind that they wanted their children to be educated. They knew that this was the only form of education they'd be able to get for a while, and so they wanted their children to get that education. But others stood firm on the belief that they had to have the schools that were in fact negotiated in the treaties. The residential schools very quickly developed a reputation for institutionalization and tolerance, that children were separated from their families and from their communities, that they were demeaned, they were being physically punished, and that they lived in fear and oppression while in school. Their language was denied, their relationship with their brothers and sisters and with their communities and with their parents was very severely interfered with. They were denied access to their culture, and they had imposed upon them European religious belief systems, Christianity. Death rates in the school were phenomenally high. One study that was done by a senior government official by the name of Dr. Peter Bryce in schools in Saskatchewan found that the death rates were in the area of 24 to 42%. And he wrote a report to the Government of Canada about his findings and indicated that he was very concerned. One of the statements that he put forward in his report was that the government was coming very close to being guilty of the crime of manslaughter if they continued to run schools as they were running them. And for his efforts, Dr. Bryce was removed from office. In the schools, in addition to the physical punishment that was being used and the discipline that was harsh, we knew that children were also being physically abused and injured by staff in the schools and by staff who were visiting from other places as well. So people who didn't even work in the schools sometimes were abusing the children. Sexual abuse became quite rampant, and that led to bullying among the children, and emotional violence was imposed upon the children. The schools themselves were not really schools, and we said this in our report, that they were really run like orphanages. There was very little in the way of curriculum. There were no educational standards for most of the history of the schools, and the education that the children received was totally inadequate. None of the children, in fact, ever were able to use their education in residential schools to be able to go on to post-secondary education. They had to transfer to a different school system in order to upgrade their education to acceptable standards. Those who taught in the schools were not required to be trained as teachers, and we know that many of them, in fact, never did have any teaching background even when they came in. That was not the requirement, keep in mind. The requirement was that they had to be devoted to indoctrination of these children into a different culture. So a great deal about the schools was hidden from Canadians. And we know that over the course of a number of years, 140 schools were actually operated directly by the Government of Canada. And the reality is that for the children who went through those schools, which totaled about 150,000, there was very little resemblance to anything that resembled a higher or even basic education, which is what the Indigenous leaders had negotiated for in the treaties. The children who went to those schools did not learn any marketable skills, any skills that would allow them to function and get employed in the dominant society. And they certainly lost all knowledge about their traditional ways of life. The schools themselves were understaffed, the teachers were underqualified, and food shortages were rampant in the schools. And that had a great deal of impact upon the children's health and left many children weak and conditioned and very susceptible to diseases such as influenza and tuberculosis. Children died in large numbers from those diseases. But in addition to that, neglect and violence were common within the schools. Punishments were administered frequently and were quite severe. Incidents of attempted escape were not uncommon, and unknown numbers of children died from exposure when they did run away. The results for many others were unknown. And children who did die in the schools were buried in poorly marked and unrecorded graves. Those claims of physical and sexual abuse within residential schools characterized about 90% of court actions that ultimately were allowed to be filed in the courts against the government and the churches. And this led to some people being prosecuted, but considering the number of claims that have been made, the number of prosecutions has been relatively small. But in the early part of Canadian history, until the 1980s and 1990s, Indigenous people who went to court in order to make claims for the injuries they sustained were always denied the right to take those legal actions. And the final area I'd just like to discuss with you is the role of the parents in all of this. And if you think about it for a moment, if you were a parent and this was happening to your children, what would you do? Clearly, you'd resist it if you could. You'd protest it. You'd go to court to try to stop it. You might even challenge it through the political process, and you might even go to war. Now, for those who thought about resisting, legal punishments were imposed on parents who failed to send their children to a residential school, and we found many instances of parents who were locked up in jail until they agreed to send their children to the school or disclose where their children were so they could be rounded up and sent to the schools. Every fall, in the latter part of August and into September and October, the RCMP, military authorities, and government agents attended communities and literally rounded the kids up, took them away in large numbers. Some communities, in fact, would lose all of the children to these roundups. And we know that the cost of doing so at that time must have been quite enormous. But we also know that some of the parents were able to successfully hide their children, and we heard stories about some of those successful resistance. Indigenous people, in fact, found that if they left the country, those who were in the southern part of Canada, for example, if they merely moved across the border into the United States, they could get away from those roundups and they could be prevented from being legally required to send their children to the schools. So in Nova Scotia and New Brunswick, you see a lot of Mi'kmaq people who went to live in Maine, Maryland, Massachusetts, and the Prairie provinces. A lot of Indigenous people moved across the border into Montana and North Dakota, Minnesota. In British Columbia, a lot of Indigenous people moved into the state of Washington. But the government was not only concerned about attacking the culture of Indigenous people by removing the children and indoctrinating them, they were also concerned about stamping that into culture and the authority of Indigenous leaders and the rights of Indigenous people altogether. So laws were passed which made it illegal to participate in large Indian gatherings. Ceremonial gatherings were outlawed. The Sundance laws and the potlatch laws, for example, of the 1880s remained on the books for about 70 years until the 1950s. And laws were passed which made it illegal for Indian people to wear Indian garb, whatever that meant. And movement became restricted, so you couldn't leave your community unless you got a written pass from the government. Indian pass system was created. And it became the model for the pass system, which was adopted by the government of South Africa during apartheid. The right to go to court was restricted, of course, so if you couldn't resist, then you might want to go to court, but the right to go to court was restricted. Any Indian who wanted to sue the government had to get permission from the Minister of Indian Affairs first, and it was impossible to get that permission. Getting legal advice became prohibited. Any lawyer who agreed to advise or assist an Indian to take action against the government of Canada would be disbarred unless the government gave permission for him to give that advice at all. And even those who were friends and supporters of Indigenous people could not take legal action to support because they also had to get the government's permission to do that. So if you couldn't resist and you couldn't protest and you couldn't go to court, maybe you could vote these people out of office. Indigenous people in Canada had the right to vote in the 1880s for about 6 years. And in 1891, the government took away that right through a law, interestingly called the Indian Advancement Act. Indians lost the right to vote in 1891. Traditional leadership was removed from being an authority in band councils. Indian Act amendments required that all bands had to elect officers who were qualified only in accordance with the Indian Act, and only men could be elected, and only men could vote for them. So the role of women in community decision-making was virtually eliminated. And those elected councils were restricted in their power. They were also closely supervised. Anytime an Indian band council wanted to have a meeting, the Indian agent had to be notified, and he had the right to attend, and he had the right to chair those band council meetings as well. So you can see how this history would have had an impact upon individuals through emotional and physical trauma, language loss, cultural loss, loss of identity, loss of pride, loss of self-respect, and impact on their capacity to cope with just everyday things in life. Respect for education would have been impacted and diminished. The respect for the government of Canada and perhaps governments generally were lost, and the respect for this country became lost as well. The Aboriginal Healing Foundation, in their research series, developed a study looking into the mental health of Aboriginal residential school survivors in British Columbia, and their findings make for interesting reading. And then once residential schools started to close down after 1951, and those closures, incidentally, came about as a direct result of international efforts, the UN Declaration on the Rights of the Child and the United Nations Convention on Genocide had a very severe impact on the government's willingness to continue residential schools. But in the 1960s, we see a second wave of separation. We see the child welfare system taking children. We see rates of incarceration starting to increase among Indigenous people, and we see criminal victimization at the hands of Indigenous people as well as at the hands of non-Indigenous people starting to increase as well. Today, we know that about half of all children who are in child welfare care in Canada are Aboriginal kids. More children, in fact, are today in the care of government agencies that have been taken into residential schools during their entire existence. And most children who are being removed from their families today are being removed on the basis of allegations of actual or potential neglect and not because of any abuse that's proven to have occurred. And we know that newborn children are being apprehended from hospitals at alarming rates. In the province of Manitoba, the child welfare system apprehends one child every day from a hospital somewhere in the province who was born to an Indigenous mother. And we know that for the longest time in the prairie provinces, teenagers in the latter part of their care from 16 on were often being housed alone in hotels by the child welfare system, and no effort was being made to reunite them with their communities. Foster homes are not required to be culturally appropriate, and most of them are not. There's no legal requirement, in fact, for culturally appropriate placements in Canada. Foster home background checks and supervision are a concern to almost all of the child protectors across Canada who are monitoring the work of child welfare agencies. And foster and adoptive breakdowns are exceptionally high for Indigenous children, leading to teenage runaways and the kind of situation you see on the streets. Indigenous child welfare agencies are chronically underfunded. There was a recent decision of the Canadian Human Rights Commission into that, and the government is still resisting to fund them on the same basis they fund non-Indigenous agencies. And this lack of proper funding is similar to the lack of proper funding that the residential schools experience as well. And today, in terms of incarceration, Manitoba is one example I just can talk about with some knowledge, and that is about 70% of all of the men who are locked up in the jails of Manitoba are Aboriginal men. About 80% of all of the youth who are locked up in Manitoba are Indigenous youth. And about 90% of all the females who are locked up in Manitoba are Aboriginal females. This is similar to other prairie provinces. And interestingly, and not coincidentally, I think, this is also the part of the country where the largest numbers of residential schools were in existence. In the federal system, the numbers are equally high and negative. About 20% of all men in the federal penitentiary system are Aboriginal men, yet they represent only 3% of the national population. And 41% of all women who are locked up in the federal system are Indigenous women, coming from 3% of the population. Women, Indigenous women, are 8 times more likely to be the victim of a violent offense than non-Aboriginal women are. And among Indigenous youth, homicides and suicides are the leading causes of death. And as a result, a life of neglect often ends in a death of violence. So, and we have seen in the last 20 years the proliferation of Indigenous street gangs and sometimes puppet gangs established from other gangs taking up their lives as well. So all of this points to the grave injustice that has been inflicted upon Indigenous people since Confederation, directly as a result of the work that was done by the Government of Canada in establishing residential schools. But you have the right to think, well, only about 35% of Indigenous people ever went to a residential school, and yet this phenomenon seems to be very widespread. And it's partly because it also, the way that Indigenous people were treated in the residential schools was also the way they were treated in the public schools. So in the public school system, Indigenous people were talked about as though they were inferior, they were heathens, they were savages, they had no rights, that they were barbarians and uncivilized, and that they were lucky that the Canadian government took them under wing and tried to civilize them and save them from extinction. And that myth has been perpetuated virtually since public schools started to become a widespread phenomenon just before the Second World War in this country. But that teaching has not only had an impact upon the Indigenous children who went there, it's had an impact upon non-Indigenous children. And that means that Indigenous children have been taught to believe in their own inferiority, and non-Indigenous children have also been taught to believe in their inferiority. But all children in the public schools have been taught to believe in the superiority of European civilizations and European societies who came to this country. And that has created a very wide schism between the two populations of people in this country. Canada has not only not come to respect Indigenous people, but they've also lost the respect of Indigenous people. And so that has come to manifest itself in ongoing tensions and litigation. Courts of this country have been embroiled in helping to resolve many of these disputes. In fact, most of the work on reconciliation in Canada has largely been led by court decisions since 1973, with a decision by the Supreme Court of Canada called Calder, which recognized the validity of Indigenous rights and Indigenous title. But since 1982, and the Charter of Rights and Freedoms was established in Canada, which gave recognition, among other things, to the existing Aboriginal and treaty rights of the Aboriginal peoples in Canada. Courts have also been called upon to play a role in helping to define what those rights are. More and more, I think Indigenous people are now prepared to turn to the courts in order to enforce their rights, their collective rights as Indigenous people, but also their human rights. So challenges are being brought about in the courts, such as the litigation that led to the Indian Residential School Settlement Agreement, where Indigenous children who are now adults who had been victimized by the violence in those schools took the government and the churches to court and won. You now see litigation in which those children who have been taken away from their families through the child welfare system have been able to successfully maintain class action against the government of Canada. And the government of Canada has been found legally liable for failing to protect those children from what was essentially a very racist policy in the 1960s. And that racist policy continues even today. And my suspicion is that it's just a matter of time before children who are being caught up in the child welfare system today will also be able to successfully sue the government, not just of Canada, but perhaps the provinces as well. So injustice is, in Canada at least, is beginning to see a little bit of light at the end of the tunnel with the assistance of courts. But we have to keep in mind that injustice through court actions and resolution through court actions is expensive, time-consuming, and sometimes results in an answer that is not in keeping with the cultural beliefs or desires of Indigenous people. Sometimes the best resolution is one that can be negotiated. And my hope is that the country, the government of Canada in particular, but the country generally, will take up our major call to action, that we should all join together in trying to establish a relationship that is founded upon mutual respect, and that we will, as part of that process, engage in acts of acknowledgement, declarations of awareness, acts of atonement, and action to ensure that not only does this not happen again, but that everything is done in order to ensure that the damage from the past is fixed. So those are my thoughts and my comments for you on this day. And I want to thank you again for allowing me to be part of this. We did not shy away from declaring the actions of government as cultural genocide, but I will tell you quite frankly that we were limited in our mandate as a commission for declaring a legal conclusion. But I have no difficulty in saying to you personally that what the government did when it established residential schools was an act of genocide and fell clearly within the Charter, the Convention on Genocide, and in particular Article 2E, which said that it is an act of genocide to forcibly remove children from one racial group and placing them with another racial group in order to wipe out their original racial identity. And that's what the government did. And I think if the government itself is not prepared to recognize that, then those who are doing work in that area need to continue to maintain that work so that the rest of the country comes to understand it as well. Thank you very much.
What an amazing conference, eh? I just want to just tell a few words. You know that I'm a strong believer in mediation. Eh? And some years ago, the governments asked me to, they entrusted me, I would say, to the mandate to conduct mediation between two First Nations with a history of conflict. And you know, one of my students from the Faculty of Law, McGill Faculty of Law, a young refugee from Kosovo, attended the first joint meeting of the chiefs as a secretary, of course, all bound by confidentiality. And at the outset, I asked him to share with the chiefs his experience of violent conflict war. And this was on purpose, because, you know, I knew that we will create a sort of climate of care. And I wanted to create a true momentum with spontaneity. This young man shared what it was like to live through war, wounds, exile, and his distress as losing both his parents during the conflict. A refugee at the age of 15, he's been working all these years in order to support the cost of his education. Very brave young man. This was a moving moment, and it helped foster a climate of care and mutual trust. And then, one of the chiefs shared his own story of having been kept from the age of 5 years old to 18 years old in residential school, coming back home not speaking the language with his parents, not being able to communicate with them. And with tears, turmoil, emotions, he shared his story with us. And again, it helped foster a climate of care and mutual trust. At the end of the day, we settled the conflict. I believe in mediation, but I believe that once we have the chance to tell our story, our true story, and being sure that we are truly listened to, it creates a great moment of peace and reconciliation. I truly believe in it. We will not retain Senator Murray much longer. Senator Murray, you've been so generous with all of us. Khalil Gibran wrote, generosity is giving more than you can. And that's just what you did with us today. Thank you so much for your inspiring speech. And we all wish you a complete and speedy recovery. Our thoughts are with you.
Thank you very much. And I want to wish all of you well and safe journeys back to where you're going. And I have to go back to the hospital as soon as I'm done here. So thank you very much.